Even shows like The Last Defense mislead the public. Let me show you what I'm talking about. This refers to Chris Frosch and Jimmy Patterson taking the Fifth Amendment during the trial. We have to keep in mind that Douglas Mulder called Jim Patterson up for the defense. The reason that he called him up is because he was going to accuse him of a crime in open court, knowing that he would take the Fifth Amendment based on being accused of that crime. He said, "You're going to jail," in open court. But they don't tell you a whole lot of stuff. Even my dog doesn't agree with this stuff.
The prosecution has been on a roll here. Not anymore. The lawyers for the state have been knocked back by a big surprise sprung by the woman's lawyer, Doug Mulder. Mulder put the lead case investigator, Rowlett Police Detective Jimmy Patterson, on the witness stand.
Why do you want to call Detective Patterson as a defense witness?
Well, you ask Detective Patterson or come back Monday and you'll find out. I wanted to call him today.
He's going to be a pretty hostile witness to you, though, isn't he?
Well, I don't know if he's hostile now. He might be hostile when I'm through with him.
There's a reason. And they lie. This show lies. They skip over the part where Mulder accused him of a federal crime in open court and said, "You're going to jail." If he would have testified any more about that bugging of the gravesite, then he would be, in a sense, be testifying against himself, and by law, we don't have to do that. We can take the Fifth. So he wanted to consult with the lawyer before he spoke any more on this. Listen to the way they portray it.
The defense was about to reveal a bombshell about the tactics of the police with a piece of evidence that had not been revealed.
This little clip that they show here of that service is all that we'll ever see, and Darlie Key is in possession of the whole 14-hour tape, according to her.
They started to testify about some of the things that they knew, and when Detective Patterson was questioned as to a memorial service that was held for the boys,
He was more than just questioned. He was accused, and he was told he was going to jail. It's in testimony.
He says, "I'm not going to talk about that. I take the Fifth Amendment."
my jaw almost dropped.
He didn't say he was not going to talk about that. I take the Fifth Amendment. The judge even suggested that he might want to take the Fifth Amendment on this because he's being accused of a crime in open court. He didn't say, "I'm not going to talk about this. I'm taking the Fifth Amendment." It didn't happen that way. The transcripts tell the truth. This show is a lie.
I'd never, in 20 years, ever heard a detective taking the Fifth Amendment.
Right. Have you ever, in 20 years, heard of a detective being accused by the defense attorney in open court and say, "You're going to jail"? Have you ever seen that?
Patterson, faced with this issue, took the Fifth Amendment and would not testify.
And would not testify anymore about that issue. He didn't have to talk about the tape anymore, but he could talk about anything else within the case. It was simply that he was accused of a crime. He did not have to testify. And that's basic law 101. Darlie had the right to take the Fifth, and she did take it. She did take a Fifth. She said, "Well, my lawyers told me to." I believe it was at the bond hearing. I could be wrong. But she did take the Fifth in a different court case.
We called his second detective, and he takes the Fifth Amendment and won't testify.
He won't testify about that. And remember, they were called by the defense. The defense didn't ask him any more questions. Doug Mulder wanted to put that show on to make it look like, these detectives are taking the Fifth, but they're not telling you why.
These are the lead investigators, and the state has not called them.
The state didn't call them. Nope. The defense did, so they could put on that show.
Why is that?
The reason prosecutors didn't call Patterson to the stand, there was a moment that few knew about. A memorial that took place before the silly string video.
That morning, the police set up surveillance and mic'd the grave for sound.
Which is common. Which is common. Now, I'm going to explain this again because Kathy Cruz gets ready to tell a big-ass lie.
And had a camera in a van nearby recording activities in this memorial service. And apparently they thought somebody was going to stand over the children and confess.
It has happened before in other cases where people utter things during a funeral procession or a funeral. Even Darlie, at the funeral, she told the boys, "I'm sorry." And everybody heard that.
The issue here is, did they illegally place recording devices?
They did not illegally place recording devices, and they were charged with it, and they were found not guilty because the law states that in public, you can't expect the right to privacy in a public place. You can't. That's always been the law. That's why that's why they did this. That's why they asked, first of all, they asked Rest Haven for permission to do that on their property.
At the gravesite. And so the question became, was this a legal act?
It was a very legal act, and it was proven to be a legal act.
Ultimately, the cops were not charged with any crime.
That's a damn lie. They were charged with it. They did go to court about it, and they were found innocent because you're not able to expect privacy in a public setting. That's a lie right there.
For the recording devices at the gravesite.
We had scheduled a prayer service at the cemetery, and we prayed and we cried.
They only showed this little clip. That's it. That's all you're ever going to see. And Darlie Key's got it. Now.
And we loved each other.
Rowlett investigators basically planted a wire. They may have violated federal law by doing that because
They did not violate federal law, and this bitch knows it.
Because people at a gravesite have a reasonable expectation of privacy.
No, they don't, because you're in public, and she knows this. We had Kathy Cruz in our groups before. She would sit around and linger around, but she would not answer a single question. So we booted her. If you're just gonna, if you're not gonna participate, you're gone.
Father, we pray that you put a hedge around this family and protect them. Father, may this day of birthday be a day of rejoicing.
When you take the fifth, it means you have some culpability somewhere, or you're afraid you do.
You're accused of a crime. He said you're going to jail.
And
so why did Darlie take the fifth? This is Chris Frosch, and there's Jimmy Patterson.
Detective Patterson was afraid that what they had done was illegal.
That evidence was...
He wasn't afraid of it. He just wasn't sure he was going to get accused of a crime in open court. So rather than talk about it, he wanted to consult with his attorney first. And he did. And his attorney told him, well, there's nothing illegal there. But nobody called him back to the stand after that.
Never presented. The jury never saw that. You have to wonder what would have happened if jurors had seen the other video.
Well, the fact of the matter is, and I think I'm going to be able to show you here in just a second, is that Greg Davis said he had no problem with that tape being shown. And Doug Mulder did not want it to be talked about. Doug Mulder wanted to put on a show. Like, as if these guys have something to hide about the crime. They spoke about everything else in the crime. Just not that tape.
That showed another side of Darlie.
It did not show another side of Darlie. And that's why Doug Mulder didn't put it on.
Particularly in a close case, jurors want to see the defendant take the witness stand.
The word was out. The mother accused would take the witness stand. The people came, and they kept coming until the courtroom was packed.
All of that stuff that had been out about what she had said and done already needed to be answered. There's always been a lot of discussion about the decision to have Darlie testify.
They didn't want her to testify. It wasn't a decision to have her. It was Darlie's decision. They did not want them. Most of them did not want her on the stand.
Darlie's decision to take the stand at trial, in hindsight, probably was not a good idea.
Now I'm going straight off of the trial transcripts with this. You can see under direct examination that he's called by Doug Mulder, the defense. You can see that. I'll move down just a little bit. I'll get to the part. Talk about his notebook first. He wanted to get him to say he didn't write notes immediately at the scene, but he wrote a report later. So I want to move down. He was just trying to get him on the whole taking notes thing. But if you can look at the arrest warrant, Jimmy Patterson is the one who wrote the arrest warrant. All his notes were there. Everything that the reason that he wanted to present to a grand jury, the reasons were there. It was all there. He just wrote them later. I didn't take any notes, no. But he wanted to make him look bad for that. But the arrest warrant should have been brought up by the state, but they didn't because the notes were actually there. Talking about how long they were there with him. Now, let's see here. Let's move down here. First, he wrote him about the notes. Note right here, he says, John, the fifth, well, you know, Judge, it kind of depends on it has interrupted our strategy in this case. And, you know, I can go with either way. I don't care what the rules are. This is Mulder's. Just as long as I know what they are. If I understand what the rules are, I can play by anybody's rules. Since he was accused of open crime, a crime in open court, they both obtained attorneys. Right? Because he was accused of a crime. Anybody that's accused of a crime in the United States of America can take the fifth and retain an attorney. And Mr. Patillo, have you conferred with your client, talking about Patterson, after he was accused? Yes, I have, Your Honor. The court. And what is the result of that conference? We will decline to testify any further in this matter. And my client, on my advice, will take the fifth. As regards to microphones at the cemetery, yes, sir. All right, will you have Mr. Pickle and his client step in, please? And let the record reflect that Officer Frosch, and I'm embarrassed I have forgotten your first name, Officer Chris Frosch, Chris, the court, FROSCH, is present with his attorney, Mr. Steve Pickle. Have you conferred with your client? And what is the result of that conference? Your Honor, Detective Frost would like to assert his Fifth Amendment right. It's a right when you're accused of a crime. Concerning the testimony as regards to the recording devices or the microphones or whatever that were put up at the cemetery, and only regards to that, concerning only that portion. Is that correct, Mr. Pickrell? Is that correct, Your Honor? All right, fine. All right, fine. The court went with that. But they're only not going to talk about that unless they charge them. And they did charge them. Yes, sir. And at the time, we believe this testimony is not relevant. It is improper impeachment. And again, I'm talking about the subject of the mic on the gravesite. And we would ask the court to instruct Mr. Moulter not to go into these matters any further in front of this jury. Because again, we feel the prejudicial effect here of having to inform the jury that these officers have taken the Fifth Amendment. Again, we believe that the matters are irrelevant and that they are improper impeachment. Them putting the mics down at the grave was irrelevant to the evidence against Darlie Routie. It had nothing to do with the evidence that they had against Darlie. And he's absolutely right. The state is not going to use anything that came out of that. That is correct. We are not going into that matter. We are not going to offer any of these recordings, video, otherwise. So we do not intend to talk about that matter in front of this jury. Was there any exculpatory material in that? No, sir. But in caution, I did turn over these matters to the defense. So the defense has those tapes? Yes. You gentlemen have those tapes? Judge, Doug Moulter, Judge, they are the ones who first went into this matter. We didn't go into anything at the gravesite. They did. But he's the one that accused Patterson. All I want to know right now, Mr. Moulter, is do you have those tapes? Mr. Douglas Moulter, well, I have some tapes. I don't know whether I have those. Did you listen to them? Yes, sir. When were they given to the defense? Well, we didn't get the case until, Greg Davis interrupts, probably sometime in November, I believe. That means Greg Davis, they turned that over to the defense. The defense had it. It was in discovery. So if it's like everything else, it came in at the last minute or sometime in January. Well, let me describe that, Your Honor. There is a videotape that is obviously taken from a vehicle near the gravesite that you can see panning in on various people, and then you can hear the audio. Sometimes the audio, it depends on how close they were to the mic, on whether or not you can hear it. But the video it starts off with some gentleman out there watering the grave sites, apparently an employee, and I'm guessing it covers maybe as much as 14 hours that day. Well, then the video does, Richard Mosty cuts in, so it's hard to say. In our copy, I don't know what the state's copy is like, but our copy is not all so great on the video part. Judge, I would like to point out to the court that I think a felonious conduct on part of the police officers during an investigation is always material. It goes to the integrity of the investigation. And whether they like it or not, they're the ones that opened this up. They did not open it up. We didn't go into anything on the gravesite. The prosecution did. They were talking about the silly string. That's what they meant. And now, they have to take the bad with the good. They were smiling and telling jokes when this video was for the jury, and now they have got to take the corresponding responsibility of what has brought. So, anytime the investigation has been compromised by felonious conduct on the part of the officers, it's always admissible to the jury. And I would certainly caution the court, or remind the court, that they can't take the Fifth on part of their testimony. They are like everybody else when it comes to getting on the witness stand. They can't assert the fifth to a certain matter. And they can't and say, I don't want to talk about that. And I want to hide behind the Fifth Amendment. Mosty says, and not only on the relevance issue, the court has got to remember that Cron has testified that he decided within 20 minutes that the defendant's guilt. He never said that. That the Rowlett Police Department was informed of that Mr. Davis was on the job within 5 days after that, and that this and the whole focus, I said in my opening statement, she became the target in the rifle scope at the beginning, and the methodology of how Rowlett went about investigating this by choosing not to investigate other things is directly shown by going out and putting an illegal bug into a graveyard, which it wasn't illegal. The court says, okay, so you're using that to impeach these officers? Is that correct? I don't know that impeach is the right. Not exclusively. We're using it to show what they did. Just a simple fact of how they investigated it. But Judge, once again, they brought it up. They're talking about the silly string. We didn't go into this matter. And now they've got to take the bad with the good. The court let Mr. Hagler make his objections. Those are the real objections. Mr. John Hagler. Well, Your Honor, a couple things as far as the facts. They are arguing irrelevancy, Your Honor. Again, I think Mr. Mosey has already stated that certainly it's relevant. The fact that the defendant was targeted within this case, within 20 minutes as being the assailant, which is not what was said. And certainly this would have some relevancy to the jury in our showing that there is a motive on the part of the police department to actively pursue the defendant and target her as the assailant in this case. Secondly, Your Honor, they have again, of course, offered the tape. They made the issue of the graveside matter in this case, talking about the silly string. They have injected this matter in front of the jury. Certainly we're entitled to bring out all of the circumstances surrounding the gravesite matters. You know. Furthermore is the fact that they have made the issue of lack of remorse at the gravesite an issue. And we are entitled to elicit all of the testimony from these officers. I might mention they are talking about tapes and video. Now, to my understanding, and I don't know all of the facts, but obviously there was an open wire at the gravesite. There may well be matters other than that appears on the tape and the video surveillance. Of course, the tape is intercept, but the problem we have is we don't know what all transpired out there. We don't know who was privy and overheard all of these oral conversations, as I understand it. If the court denies us an opportunity to confront and cross-examine these witnesses, we are denied the opportunity of eliciting all the facts and testimony surrounding the gravesite event and incidents. And I would further submit to the court that the court can't simply rely on the blanket assertion by the state that there is no exculpatory statements made during any of these intercepted conversations. I think it's for the court to make that decision. It's for us to be able to elicit such information by means of cross-examination and confrontation. Your Honor, but if the court rules that and prohibits us from cross-examining the witness concerning their knowledge and the conversations, the events surrounding the illegal intercept of the conversations at the gravesite, that would constitute a violation of the defendant's Fifth and Sixth rights under U.S. Constitution and the 14th Amendment rights. And Article 1, Section 10 of the Texas Constitution. Specifically, the right to confront and cross-examine the witnesses concerning the events surrounding the illegal intercept, which it wasn't. Furthermore, Your Honor, it would also prevent us from going in or offering in front of the jury the testimony regarding the credibility of the witnesses, their motive, and intent surrounding their investigation in this case. The court says, all right, fine. The court finds that. The court holds this improper impeachment evidence. The officer's actions do not reflect upon the officers. The officer who has testified so far, his actions do not reflect upon his character for truthfulness or untruthfulness regarding his testimony in this case. Any recordings they may have made were not admitted into evidence, nor was there an attempt to admit them into evidence. For these reasons, I find that the potential prejudice outweighs the probative value of this evidence, and the defense is ordered not to go into it, should these officers be recalled into the stand. Now, if you want a running objection on that, you may have it. John Hagler says, yes, Your Honor. Mr. Mosley says, Your Honor, we could go into, for instance, things that refute on that tape, refute the inference that the state has done. The court says, there was a videotape done by Channel 5. I think everyone in the country has seen it out there. Well, you know, what they didn't see was the funeral service. The state has illegally intercepted the funeral service where they stand around and pray. The state offers the silly string part of the day, and they have the prayer there, where the first part of it is prayer, where they were illegally intercept a prayer at the gravesite, and we can't offer that. The court says, well, I think that has already been offered. You know, Your Honor, we have a video of it. Greg Davis, I don't think there's any problem with Mr. Mosley or Mr. Motor offering that videotape. This is what they don't tell you. Well, put it in then. The prosecution said, we don't have a problem with you putting that tape in. I mean, whatever was visually recorded out there, we certainly don't have a problem with them doing that. It's just circumstances under which what has gathered. You know, if they could show what happened out there, if they want to show the videotape, they could show it out there, but they can't go into saying it's illegal. They could show it. They wanted to show it. But we can't ask so they have that option. And if they will get to show what they feel is important for them to show the jury. Well, anyway, that is fine. If you want to do that, that will be fine. But that is the court's ruling, and the court will note your objection. You don't have to object in front of the jury for any purposes. You will have a running objection, and at 9 o'clock we will proceed. Yes, sir. Just so I'm abundantly clear on this, you're telling me that if I recall Detective Jimmy Patterson, that I can't go into the matter at all? Of the illegal, of how they got that tape. That's correct. Mr. Douglas Moeller. Okay, Mr. Richard Moeller. And we can't even go into the motive of how they conducted their investigation? It's been a central theme of this case from the beginning, is that these men went to the stage of illegal activities to try and get a target on this lady that has begun the beginning of this case. And is exactly what this case is about. In its entirety. Is that they never did anything other than focus on Darlie. Because they couldn't. There was no place else to focus. And they wanted to do it so bad that they would violate state and federal law to do so. And we're not allowed to go into that. Court, well, the court ruling stands. Judge, let me ask you this for a little direction from the court. Does the court intend to give the jury any explanation or clarification, or just let it? Well, we will go over the charge at the appropriate time. I'm happy to do that. I mean, you don't intend to say anything to the jury. You know, he was plucked from the witness stand rather inappropriately, and I take it the court doesn't. Well, I think both sides agree with that, and I don't think he was plucked from the witness stand. Well, he refused to answer my questions, Judge, until he had a chance to talk to his lawyer. If they call, if I understand, if I call the officers, I can't go into it. If they call them, can I go into it as an impeachment? Well, certainly. If any door is open, I don't think they will be calling the officer. But they may very well do it. But we want to stay out of that. The court says we are not going to go into whatever happened at the gravesite as regards to the alleged recordings out there. Well, what about the other officers who did it? Can we call them? Because they want them all to take the fifth. That's what they want them to do. We will go each one individually at the time. All right, anything else? Just so I'm clear, Your Honor, you stated that, of course, we cannot question them in front of the jury, but we are also prohibited from questioning them during the hearing as to any and all statements. You may question them during the hearing. Do you want to question the officers now? Well, one thing we want to know is everyone who was involved in this. Well, can you give them the information? And who knew about it? Who participated in it? Who planned it? Mr. Greg Davis, that I don't know. I don't know those facts. Well, maybe Mr. Davis needs a lawyer. Well, maybe you do. The court, well, I doubt that. I've got one. I doubt that. I think both sides. All right, gentlemen, fine. Excuse me. Go ahead, Mr. Davis. I was just going to say in this matter that we can all be clear. If Mr. Mulder believes that the door has been opened, would you please instruct him to approach the bench, discuss this matter with you before he begins to go through that open door? Because we both know what he is going to do here. He has done it in the past. Judge, I'll know when the door is open. Both sides are so instructed to approach the bench. Before you do that, if that is necessary. Yes, sir. Yes, sir. Thank you. Yes, sir. So we won't have a repeat of what we did on Friday. Judge, I'll do that if that's not clear. If there wasn't anything, and there wasn't anything Friday. There wasn't anything Friday about this business. No, I'm talking about the other agreement that we had. He broke on Friday. There wasn't any agreement on Friday. Not to go into the fact that Patterson was. Gentlemen, Friday has passed. Friday has passed. What occurred, occurred. Well, okay, yesterday. Well, I didn't make any agreement with them. Maybe blah, blah, blah. They're just fighting with each other over this. Motions of limine. He wanted to get all of them. Yep, he didn't want the other ones to be accused of a crime either, so he said that. Mr. Doug Mulder. Well, he answered that or he goes to jail, doesn't he? Mr. Mulder, if I want anything from you, I will ask you. Is that clear? Well, yes, sir. You are right here. Blam. And that was that. He accused him of a crime. See, they were basically saying that since Davis put in the silly string tape, that he would question the legality of the surveillance tape and in front of the jury get all of these officers that were involved in it to say, no, I take the fifth. No, I take the fifth. That way they could gain an attorney just in case there was a crime, just in case they were charged. And in the end, it was ruled that you can't expect any privacy in a public setting. So that show lied. They didn't tell you that he said, you're going to jail. You committed a crime. And as soon as he said that, Jimmy Patterson said, fine, I'm not going to talk about that anymore. And he didn't. But they could testify to anything else. Doug Mulder didn't bring him back up to testify about anything else. Neither did Greg Davis. He just wanted to put on a show for the jury. That's it.